On January 13, 2026, two entirely contradictory legal realities arrived on the exact same day, creating an impossible procedural trap. In state court, Judge Blanco issued a final denial of Gerald Hirschfeld's motion for reconsideration. By ruling that the challenge was time-barred, the judge effectively closed Gerald's ability to seek relief through the state system. Yet at the same time, the Larimer County Records Department provided a written response to Gerald's records request. They explicitly admitted they could not produce the foundational 2015 child support order, stating it does not exist in the official court file. This created a procedural deadlock. The county was garnishing his wages and suspending his driver's license based on an order they admitted they did not possess, while the state judge refused to hear the challenge. Ordinarily, federal courts cannot review state court domestic relations judgments due to the Rooker-Feldman doctrine. Gerald bypassed this barrier by arguing that because the 2015 order never existed, the county's actions were not judicial enforcement at all. He characterized the collections as unconstitutional executive seizures, executed without a valid judicial predicate. By documenting the absence of a foundational order, Gerald escalated a family law dispute into a federal civil rights lawsuit against an executive apparatus. His complaint identifies Larimer County as the primary target under a Section 1983 Monell claim. Under Monell, a plaintiff must prove that a government agency operates on an official policy or widespread custom of violating constitutional rights, rather than just isolated errors. Gerald identified 5 customs. The first is worksheet fraud, using the wrong mathematical formula to calculate debt. Despite an official admitting the plan established shared custody, the agency applied worksheet A for sole physical care, assuming one parent bears all daily living costs. This algorithmic choice maximized the support amount, manufacturing an estimated $70,000 in debt that would not have existed under the shared care formula. The second custom details the use of automated punishment without evaluating an individual's financial reality. The state suspended Gerald's driver's license for non-payment while he was unemployed and homeless. In Turner v. Rogers, the Supreme Court held that the state must provide an ability to pay hearing before imposing coercive sanctions like a license suspension. The county agency bypassed this mandatory constitutional safeguard, operating as an algorithm that punished poverty rather than evaluating an individual's ability to comply. By prioritizing these automated penalties, the agency eliminated Gerald's income capacity as a driver, directly causing 527 documented days of homelessness. Gerald further alleges a violation of substantive due process. For 15 months, his daughter was in full-time state-funded care. While the state was paying for her daily needs, the agency continued to seize over $12,000 from Gerald, in direct violation of federal regulations. The complaint highlights the agency's indifference to the impact of these actions. When Gerald notified a county manager that the relentless enforcement was causing suicidal ideation, she responded with a 988 crisis hotline link instead of pausing the garnishments or investigating the missing order. This disregard for procedural accuracy appeared in the agency's legal defense, where an attorney misfiled an opposition motion into a completely unrelated juvenile case involving children Gerald did not know. The agency also responded to Gerald's legal challenges with direct action. Within 24 hours of Gerald filing a constitutionally protected motion for relief, an official manually triggered a new payment demand without providing any new factual basis. During this period, the agency continued to furnish negative information to consumer reporting agencies, despite Gerald's formal notice that the foundational debt was void. This pattern of ignoring crises, filing in incorrect cases, and issuing immediate payment demands suggests the agency functioned as a hostile entity weaponizing its authority. This conduct was not limited to low-level administrative errors. In February 2026, Human Services Director Heather O'Hare officially defended and ratified the enforcement actions. Because she acted as the final policymaker, her defense of these customs solidified Larimer County's direct liability under federal law. The lawsuit now seeks significant remedies: full injunctions, $173,000 in restitution for seized funds, $231,000 in statutory damages for credit violations, and punitive damages against specific officials. This entire enforcement apparatus, the homelessness, the credit destruction, and the six-figure claims, rests on a single missing piece of paper. For 10 years, the state executed automated financial and liberty destruction based on a 2015 court order that its own records explicitly admitted they were unable to enter. It is a chilling example of what happens when an administrative machine is allowed to operate without a valid judicial predicate.